Compliance Board, and I call this meeting to order. The NSB Code Compliance Board of September 18, 2025. The procedures of this hearing are to provide due process to every respondent and the city in accordance with Florida State Statute 162.073, which states, formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceeding. Hearsay is admissible, but only to support other competent, substantial evidence. Other evidence must be presented. Are there any questions? Any decision made today can be appealed by sending notice of appeal to the Circuit Court within 30 days of the execution of the orders per Florida State Statute 162.11. Can we have roll call, please?
Yes. Dan Coffer.
Here.
Clifford Warren.
Here.
Albert Szymanski.
Here.
Kathleen Brown.
Here.
Ruth Harris.
Here.
Aaron Denny's.
Here.
Does any board member have any, to disclose any part-time communications?
You didn't call my name?
Oh, I'm sorry.
Yeah, you're fine. Keith McWilliams?
Yes. Keith McWilliams.
There you go.
Okay. I'll go over that again. Disclosure of any ex parte communications among the board members?
No.
Okay. Did every board member have a chance to approve or look at the minutes from the August 21st, 2025?
Yes.
And do we have a motion to accept the minutes?
So move. Second.
We're going to go ahead and do the swearing in.
No, we have to vote on the
Yeah.
approval of the minutes.
Dan Coffer.
Aye.
Clifford Warren.
Aye.
Albert Szymanski.
Aye.
Kathleen Brown.
Aye.
Aaron Denny's.
Aye.
Ruth Harris.
Yes.
Keith McWilliams.
Aye.
And now can we have the swearing in of city staff, respondents, and any witnesses that may testify before us today?
Please stand and raise your right hand. In the matter to which you are about to give testimony, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? The witnesses have been sworn in.
Okay. First case, please.
CCB 20262-2025, 406 Pine Street. Officer John Parks presenting.
Afternoon. Address is 406 South Pine Street, case number CCB-02622025. This property is zoned R2, single-family residential. Violation cited was 26-171A, permits required. On August the 21st, 2025, the board found Gary L. Tuthill, excuse me, DEC Trust and/or entity in violation of 26-171 Section A and gave until September the 12th, 2025 to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation to impose a fine of $50 per day until the property was brought into full compliance. The board order was mailed, certified mail to the property owner and is moving through the network. The board order was posted on the property on August the 28th, 2025. On September the 9th, 2025, I spoke with the property owner regarding the violation. He has submitted an application that is in a resubmittal required status involving a survey. Due to the fact that it's involving a survey, it is staff's recommendation, the board to continue the case to a later hearing date to allow more time so he can obtain a survey. Unfortunately, surveys do take time. He may have a survey that might be available and usable. However, that's yet to be determined.
Okay. Is there anybody here to speak on this case from the audience? For the record, there is no one. Any questions?
Is
Yes.
there work being done or have been done without a permit?
Everything is done after fact, so it's an after fact permit.
Thank you.
Any other questions?
Did you have a date in mind?
Due to the fact that it involves surveys, surveys sometimes take up to 6 months, and I'd hate to see it, I'd hate to put a timeframe on it to be next month, and then we have to come back and do the exact same motion again. I really believe that just leaving it open-ended, we already have it's already had one board order. I believe that that will suffice, along with this board order, to bring it back as soon as reasonable if in the event that it stalls and a survey is not submitted.
What's reasonable? What's reasonable?
Again, we've seen times after, as an example, Hurricane Ian, surveys were one of those things that became a very big backlog in the state. And we saw, not uncommon, to take 6 months to get a new survey for a property. I would say within 6 months, I would not go past that. And again, it would be based upon the fact of whether or not he's cooperative, whether or not he's communicating with us, if it seems genuine, or it seems like a legitimate statement, or it seems like a stall tactic. We take that into consideration. We would bring it back at any point that we felt there was need to move it further with enforcement.
Has the application for the permit been pending the survey?
He has submitted an application. It was in the review process. It was returned to him as resubmittal required. And it appears that what is hanging on is he needs to submit a survey. It's a fence issue, so therefore property lines are involved, those types of things. So therefore he's, one of the requirements would be a survey.
Thank you.
Yes,
Did the survey need to take place before the work was done?
Normally, the way things are supposed to be, the way the law is, that you would have to obtain a permit and a permit be issued prior to any work being done. Unfortunately, usually when we have these types of cases, most of them are after fact. In other words, the work has already transpired, already occurred. They did this without a permit, and then that would be the violation. And that's the violation in this case. It's not that there is something wrong with, as an example, his fence is too high, or it's improperly placed, or the wrong materials, or anything like that. That would be determined by the building department once the building department issued a permit and then the inspector went out. This is strictly a case where there was a fence erected without a permit.
Thank you.
Yep.
Any other questions?
I'll make a motion.
Make a motion?
I make a motion, I know we don't meet in December, right? That's, I was gonna say till the end of the year, but we don't meet in December. January meeting is, I think that's reasonable after the work was already done.
Yeah, I second that.
Thank you.
Okay, so the formal motion then will be, you want to put a
January.
date, you want to put a date on it.
By the January meeting, I'm not sure what date the meeting is. Oh, sorry.
I don't know
I
if
think
we've
officially we have
established
to-
next year's
Here, I can
hearings yet.
We can do a tentative date. We haven't adopted or approved the dates for next year yet, but looking at the calendar, we could do a tentative date of January 15th.
Okay.
I make a motion that we give till January 15th to have that all intact.
I second the motion.
We have a second?
Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Szymanski,
Aye.
Kathleen Brown,
Aye.
Aaron Denny's,
Aye.
Keith McWilliams,
Aye.
Ruth Harris.
Yes.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation of which a fine up to $500 per day may be imposed. Next case, please.
The next case is CCB 0359 2025 1828 Turnbull Lakes Drive. Officer John Parks presenting.
Address is 1828 Turnbull Lakes Drive, case number CCB 0359-2025. This property is zoned R2, single-family residential. Violation cited, section 74-146, local business tax imposed. On June 18, 2025, I observed a sign indicating that the property was listed for rent. A check of the BTR system found no BTR had been applied for or issued. On August the 9th, 2025, a notice of violation was posted on the property with an initial compliance date of August the 29th, 2025. A copy was also mailed certified mail to the property owner and was signed for and accepted on August the 8th, 2025. On September the 9th, 2025, a check of the BTR system found no BTR application. It is staff's recommendation to the board to find Justin Michael Pike and/or entity in violation of Section 74-146 and give until the end of October, being October 31st, 2025, to bring the property into full compliance. If the owner does not come into compliance, it's staff's recommendation per Florida Statute 205.053, a one-time fine of $250 be imposed for operating without a BTR.
Is there anybody here in the audience that would like to speak on this case? For the record, there are none. Any questions from the board?
No contact at all with the,
There was a phone call yesterday, and I do know that our BTR specialist for the city has been communicating yesterday or today, one or the other. I've seen an email today on it that indicates that there was a communication with the owner about how to go about applying for the BTR.
Do we know if it is currently being rented by other occupants?
From what I understand, there is a renter, a tenant on the property at this time. What the duration or lease is, I do not know. The sign was out there for a while. It then got removed. Then there was a vehicle in the driveway. So I really can't state what the agreement is. I don't know if it's a family member or whatever, but it does appear to be occupied.
Thank you.
Any more questions? Can I get a motion?
can you repeat your recommendation, please?
Yes, my recommendation is that the board would find, do you want me to read the entire thing, sir? For
Just to highlight it.
All right. Is staff's recommendation to the board to find Justin Michael Pike and/or entity in violation of Section 74-146 and give until October the 31st, 2025 to bring the property into full compliance. If the owner does not come into compliance, it is staff's recommendation per Florida Statute 205.053, a one-time fine of $250 be imposed for operating without a BTR.
I would make that recommendation.
I'll second that.
Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Chemansky,
Aye.
Kathleen Brown,
Aye.
Aaron Denny's,
Aye.
Ruth Harris,
Yes.
Keith McWilliams.
Aye.
Thank you.
Thank you.
Thank you, John.
The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation, of which a fine up to $500 per day may be imposed. Next case, please.
Next case is CCB 0250-2025, 614 Aeolian Drive. Officer Barbara Vogelak presenting.
Good afternoon. This case number this is actually a new case, as well as the last case was a new case, so we're under new business, just so everyone knows. And the case is CEB-0250-2025. The property location is 614 Aeolian Drive, and the zoning is PUD, which is a planned unit development. So this case has been going on, I believe some of the original contacts started in January. I ended up actually opening the case, I believe, in April, around April 29th. And we had received several complaints regarding the property being rented out. The property appears to be rented out as a short-term rental. I do have an ad from It's called padsplit.com, and they are advertising the property as weekly rentals at $189. I'm going to submit this to the board for review. I also have some photos of some vehicles that are at the property. One vehicle seems to be more consistent than some of the others. I also have some information, a couple of emails that I've received from some of the neighboring properties I'm going to submit. They are here to validate the emails, so I'm going to also submit those to you all for review. So on April 29th, 2025, we received some other complaints on the property being rented out as a short-term rental. On May 5th, an inspection was conducted and the property was found to be in violation of the land development regulations, sections 504.01N, general zoning regulations for short-term rentals, and section 504.02, zoning district regulations for planned unit development. I monitored the property. I had all the code enforcement officers monitoring the properties when they were here on weekends, just because usually that's when a lot of times the short-term rentals between Thursdays and Sundays is when a lot of this stuff, action takes place. So we had monitored the property from May to August because I wanted to make sure that I had enough evidence to prove that it's an active short-term rental. So on August 8th, 2025, a notice of violation was mailed, certified mail to the property owner with an initial compliance date of August 27th, 2025. The certified mail was signed for and accepted on August 11th, 2025, and also August 12th, 2025. I sent it to 2 different locations. The property was also posted on August 8th, 2025. On September 12th, 2025, a follow-up inspection showed a change of vehicles parked in the driveway. The vehicles at the location appear to change on a regular basis. So it seems either there's no vehicles or there's at least one in the driveway. Some of them park on the street, so it's kind of hard for us to determine which house it's at. But just from the different activity that I have seen, I believe that this is an active short-term rental. Whether they do it weekly, monthly, whether the owners are aware of it, I don't know. Maybe it's one of the tenants there that's renting out rooms. There's no way for me to actually prove that, but so we did cite them. They accepted the certified mail. I was out there today. The little silver car that's been there more often than others was there today. So, and then I did locate the ad on padsplit.com where they're offering the rooms for rent. So I have not heard anything from the owners of this property. We did have a previous case for BTR, for the business license tax receipt. To date, they have not responded to that either. So it is an active rental. I do know that for sure. So my recommendation is that the board find BG Real Estate FL LLC and BG Investment Group Holdings LLC and/or entity in violation of the land development regulations for section 504.01N and section 504.02 and give until October 2nd, 2025 to stop all short-term rental activity and to bring the property into full compliance, which to bring it, basically we're going to have to see that the ad is taken down from PadSplit, and we will still monitor it to make sure, see if how often the vehicles are changing out. And then if the owner does not come into compliance, it's my recommendation to impose a fine of $100 per day per violation until the property is brought into full compliance, and the fine not to exceed $15,000. I do know there's some ladies in the audience. A couple of them may want to just speak to let you know what they're witnessing.
Okay.
Thank you.
If you can just speak into the microphone and identify yourself, please, for the
Sure.
record.
Good afternoon. Claudia Vanderhorst, 562 Aeolian Drive. I live down the street from this property. The ladies, I'm speaking on behalf of the property owners behind me who live next door across, very close. In January, when the house was sold, there was a situation with the property to begin with, so neighbors were paying attention to what happened when it was sold, and that's when we discovered it was a rental, and just watched it. And within the first 10 days, there were 3 to 4 cars leaving, coming and going, and the neighbors approached them and said, "Oh, are you the new, welcome to the neighborhood, are you the new owners?" "Oh, no, we're just renting a room, we're renting through Pad Split, where it's an Airbnb." All got different stories. So that was the first time the radar went off. That's when we got a hold of Miss Barbara and said, "We need help." The one car you referred to that has been the constant is gone now. So now we're down to 3 vehicles, and the silver car has just been there 10 days. So it's a cycle. It's about every 10 days to 2 weeks. They're coming and going. The advertisement on Pad Split, they actually use photographs from when the house was for sale 3 years ago. It doesn't even reflect what it looks like now. And our whole community is in the ad. Our whole subdivision is in the ad as an aerial view. The one question we have, and I don't know if this is the appropriate time to ask it, is done some research on this, and we're curious why the renters themselves are not receiving notice, because they're the ones who are actively violating the code, the housing code. They're the ones who are renting it weekly. Someone needs to tell them that it's a violation, and they should be held accountable once they've been informed, because they're agreeing to violate the law or the ordinance. And my question is, do we have that? Do you have that within the power? Does the city have that within their power to execute that? Because they're actively, the host is posted, the host of Pad Split he's identified on the website. Pad Split is the host, so they should be notified first of all, and then stop taking leases, whether they're 1 week, 2 week, 5 day, 3 day, whatever they are. Barbara's doing a great job going after the owner, but it seems like we're missing the link of the actual people who are showing up and coming and going. They seem to feel like they're immune, and it's really having a negative impact on our community, for sure. So we're hoping this, I know this isn't isolated. I know this is going on in various areas throughout the city. And I've done some research on those cases as well, and I don't see anything about notification to the renters. And I think you want it to stop quickly, that'll do it, because they're not going to want to be
That would be a question for our
investigated.
attorney. I'm not sure if we have that power.
So within our regs, as well as Florida statutes, you have to go after the owner, the source of the problem. You can post the notice on the property, which might dissuade some of the renters, because they'll realize that as this goes through the process, they're no longer going to be able to stay there, but we are going to go to the owner of the property in order to stop this.
Well, on the way here, I looked up the Florida statute, and it does state in there very clearly that tenants can be noticed if they're violating ordinances and codes that involve housing. So it's something that can be done.
Yes, ma'am, and that's what I'm referring to, posting the notice on the property. However, we are not going to go after individual tenants and impose fines on them. We can impose the fines on the owner. So I understand your concern and what you're saying. The notice requirement is happening to the owner and is posted on there so that the tenants as well will be aware of it.
That's the question, is why is the tenant not being fined? Because they're the one actively breaking the law. The owner may not even know this is going on.
They're about to find out about it because this is our first public hearing on it. They
Right.
will receive the notice that they will be found in violation per Barb's recommendation if this board accepts it. They will then get that legal notice. If they don't come into compliance, the fines will then begin to run.
Just against the owner.
Correct.
Well, clearly he doesn't care because he hasn't responded to the license since January or since April. So our concern is this is going to continue to go on.
So what happens with the money then is even if he fails to pay the fine, then we file a lien on the property.
We understand that, but we're going to have to live with those conditions with that property as it exists until either the house is foreclosed or sold. So they get to continue to break the law without any recourse. So we provided license plates for the vehicles that are parking. We've gotten pictures of all the license plates so you can identify the tenants, short of sending them a letter personally as opposed to posting it on the door. Because my instinct is whoever comes in first is ripping that notice off and nobody else is seeing it, because that's the person making the money from the rentals. So respectfully, I'm asking, we're missing a step here. The actual tenants also need to be noticed and also need to be held accountable because it's allowed for in Florida state law. It is allowed for. So that is our request to you, because we think we have 2 other properties that are doing the same thing in our community. We only have 113 homes. So one of these has a huge impact on us, let alone multiple. And as taxpayers, man, we're begging you, please, do it, utilize the powers that are within your realm to nip this, because it's going to ruin our community. Thank you so much.
Thank you.
Thank you.
I'll expand a little bit. There's really no way for us to get tenant names. I've knocked on the door there several times. No one has ever opened that door for me. Also, she's questioning running the plates on the cars. Code enforcement does not have that option. We don't have the ability to run plates on vehicles. So unfortunately, that's not a tool for code enforcement. If for some reason there was a police report and I did a public records request, possibly I could use the information from the police report. To my knowledge, I don't believe that there's any police reports to date. So I have to follow the Florida State Statute 162, which is what the board is also governed by, which is what a lot of city personnel is governed by. So unfortunately, we would love to go after anybody that we could to get the properties to come into compliance. But at this time, I don't know of an option for us to do that. If Ms. Claudia would like to get me the Florida State statute that she was reading, she can send that to me. I will gladly look into it. I can share it with the city attorneys and assistant city attorneys and see if it's something that we can possibly use or adopt. Then that's another step that we could take, but it's not going to be anything that we can resolve overnight, unfortunately, as I know these poor neighbors are going through it, and it's been months now. So hopefully, if they get a fine, which we can't do until the second hearing, maybe that will open up their eyes. But it's just, unfortunately, we can't evict other people's tenants
Sure.
or anything like that unless the property is fallen down around them. And then there may be a tool that way, but this property is in good shape from what I can tell. So I'm using the tools that we have available at this time, and that's why I brought it before the board.
Do you think, my first question would be, do you think $100 a day will get their attention?
That I'm not sure of. That's something that the board can discuss. You can always go up to $250 a day, but it can't be per violation, so you would have to do like $125 per day per violation, if that's being taken into consideration.
Any other questions?
No, go ahead.
Could you remind us what contact, if any, you've had with the actual landlord, the company?
I have had no contact. They have not responded to me at all. The first case that I opened for the business license, they responded once.
Mm-hmm.
They have been non-communicative at all with me. They do accept their certified mail, so they know what's going on.
Certified mail, and when I was looking at, they're based in, what is it, Wyoming? Is that right?
I believe, yeah, I know they're out of state for sure.
And they accepted certified mail at their location in Wyoming.
They accepted 2 pieces of certified mail.
Is that the person or pad site?
The actual
Pardon?
mail.
The pad site,
Yeah.
the
Mhm.
host, is it them or a real owner?
No, it's the owners of the property listed on the property appraiser website.
Thank you.
And one went to 7904 North 4th Street, Suite 300 in St. Petersburg, Florida. That was accepted. And one also went to 30 North Gold Street, Suite 4, Sheridan, Wyoming, and that was accepted.
Okay.
There's been and I have gone on trying to find phone numbers and stuff. I have not had any luck. I've tried calling the phone numbers that are on the business license application, and I get no response.
Okay. On the actual listing for the site, The only name I saw was someone called Noel G, just abbreviated. And I know that technically we'd have to reach out to the owner, the landlord, but is there any way to contact this person, Noel? Any way to find a phone number, an email, just even if we can't?
I'm not sure. This week is the first time I was able to find the ad. I know Miss Claudia has seen it several times. So hopefully I can dig into that a little bit more as well.
That would be good.
I will tell you that I know just from the short-term rentals that are going on throughout the city, most of the people that are running the ads for these people, they're not interested in the city rules
Yes,
or
you're probably
county
right.
rules or anything.
And she's also probably right that they're just taking it down the second they see it, and the people that are there on a weekly basis might not even know, and it might just be the person who's leasing.
Right, and that's why
directly.
keep trying to make contact with someone on location. But again, unfortunately, they did not answer the doors. And I know Herman Troutwine, a code compliance officer, he actually posted the property for me. He knocked on the door when he posted the property, and he said the same thing. There was a vehicle in the driveway, but no one answered the door.
Okay, thank you.
Are you posting the violations on the door?
Yes, we post the property
Are
on
they
the front
being
door of
taken
the
down,
property.
or they,
It's being taken down.
can we somehow do it once a week? Or like, I understand what
Post
they're
it
going
once a
through.
week.
Keep posting the violations, and maybe tenants or
It's
people
not
there, they don't know.
It's not required. I
Okay.
mean, we could keep one in our vehicle, I guess, and
Okay.
post it as we go out and check it. But it's not a requirement.
Okay, thank you.
Just one quick question. What's the actual, the maximum in a case like this that would be able to be charged to the actual owner? Is that 10
The
grand?
maximum fine is $15,000.
15, okay. So we just basically have to hope that 15,000 is enough to actually get the interest of this real estate company over in Wyoming, I suppose.
Correct.
But like he said, if they don't,
But did
put a
you say
lien.
they had
That's right, yeah.
a permit to run this kind of business, a business permit to rent these, or they don't have a business permit?
No, they have not complied with that.
So that would be an additional violation?
Well, on the business license tax receipt, we can only fine $250, a one-time fine. I believe it's per year. So the year would be from the date that they were originally fined, the fine started, until the next year. So I think it's been a while, but it has not been a year. And I do know that our business license tax receipt specialist constantly sends out reminders, reminding people that you owe this, it's due on this day, and all this. And I know that she has stated that the communication that she has had with them when this started, they did not seem to be interested in getting that. For some reason, they do not want to get an LLC in Florida. Even though one of their offices is in Florida, they apparently don't want to get an LLC to submit with the business license tax receipt, which is a requirement.
Okay. Any other questions? Do we have a motion?
What was your recommendation again?
My recommendation is to give them until October 2nd, 2025, to stop all short-term rental activity and to bring the property into full compliance. And if they do not come into compliance, it's my recommendation to impose a fine of $100 per day per violation until the property is brought into full compliance, and the fine would not exceed $15,000. And that fine, we cannot actually start a fine until the next hearing.
I would make a motion, but to have the fine at $250 or $125 for each.
So you want it $125
For each.
per
for a
each,
total of
okay?
$250. To
And
get
just
their
to-
attention.
That would be each violation, right?
Right.
And just to clarify, we're required to have this 14-day period from now until, what was it, October 2nd?
Yes,
we can't
October
just
2nd.
We can't just say, like, effective now, they're not in, they're out of compliance. We have to
Well,
wait 14 days.
typically we give, and it's been known throughout, since I've been involved in code enforcement. Originally, it says reasonable time to comply, but since we have to do certified mail, it's required that we send certified mail. We usually allow mailing time, so that's why we typically go 10 to 15 days out.
Okay.
So, I mean, you can shorten that up some if you're,
That's
that's
okay.
up to the board, but usually we want to make sure that we are giving them due process.
I understand, thank you.
Okay, and just for the record, can you repeat the motion so we have it on the
And
record?
just, Barb, you're saying there's 2 violations, correct?
There's 2 violations.
And you're going to, your recommendation is $100 per violation. The board might decide they would like to increase it to $125 per violation for those 2. They'll make the motion. If there's a second, then they'll vote on it. Is that understood? Okay.
I make the motion.
I second.
Dan Coffer,
Aye.
Clifford Warren,
Aye.
Albert Shimansky,
Aye.
Kathleen Brown,
Aye.
Aaron Denny's,
Aye.
Ruth Harris,
Yes.
Keith McWilliams.
Aye.
Just a clarification on the motion. Something just hit me. That $15,000 maximum would be per violation, is that correct?
No, that's total,
That's maximum.
maximum.
Okay. The respondents are further ordered to contact the code inspector to verify compliance with this order and to also be aware that the respondents have the right to appeal the order when it comes out within 30 days. Any violation of the same code by the respondents within 5 years from the date of this order shall be treated as a repeat violation, of which a fine up to $500 per day may be imposed. And that concludes the cases.
Yes.
Correct. Any questions or comments from the board?
No.
And everybody will be here except for
Me.
you next month.
Yes.
And I'll just add, we will try to have a tentative calendar brought before the board next month for approval. So that way we can kind of plan out a little bit and everybody will have an idea when the hearings will be in
And
2026.
if you have any objections, call me.
But
or-
you won't
or
be,
email me.
Ruth, we can bring it back in November if you would like, so you'll be here.
Yeah, but it's usually the 3rd Thursday, right? Usually?
Okay, yeah, they're usually the
Third-
third.
Thursday, yeah.
Okay,
I'll be here in November.
okay, we'll bring it in November.
All right.
All right, this time I'll adjourn the meeting then. Thank you.
Thank you.
Thank you. Thank you.